Greetings. So I am here with part 3 of a 3-part series on drafting patent applications to deal with 101. And in part 1, as a little recap, I guess, part 1, I took a very cynical approach. I think it was probably a little bit too much. Basically, I said, look, 101 is a sucker's game. The only winning move is not to play. Therefore, you should draft your application really just for the purpose of avoiding 101s. So don't say what the invention is. Try and characterize it really in a way that's almost like the identical opposite of 101 or the exact opposite of what they say they want. So use a lot of the draftsman's art, be very abstract. Again, I think I overstated things a little bit, but I think, you know, there is a kernel of truth behind the cynicism, which is, look, 101 is very difficult, and it might drive one to try and do things that could theoretically be seen as gamesmanship in order to avoid it. And in any case, part 2, I said, look, it is not a sucker's game, so to speak. There are rules. Granted, they're not perfect, but there are some things that when you follow them, they appear to give you a chance to do pretty well with Section 101. So what I'm going to do today is I'm going to kind of try and synthesize what I discussed in parts 1 and part 2. So we're going to talk about ways of avoiding Section 101 to the extent possible, or putting yourself in the best position for it, and then if you can't, how you can use those rules based on the good position you put yourself in before. So really, I guess I'm trying to synthesize everything, the cynical and the idealistic, to give you the best chance of dealing with 101 issues. So, with that having been said, let's start with my recommendations for avoiding Section 101 without being cynical, right? So I had the cynical ways of doing this in the first part, and now we're going to talk about ways of doing it without being cynical. And what I want to advocate for is essentially doing the same things that I would consider to be good practices even outside of 101. So for example, when you are talking to your inventor, I would say ask, what else can you use the invention for, right? So the inventor says, oh, I've got this idea and, you know, it's great and it will allow us to do XYZ thing that has 101 issues. Okay, fair enough. What else can you use it for? Now, this, of course, is something that is useful in drafting in general because it can help you get a broad disclosure and it can help you avoid design arounds. Additionally, it can help by showing that your invention makes a computer a more effective tool because it has more applications rather than just using the computer for a specific application, which is where you're going to have more 101 issues. Similarly, you're going to talk to the inventor and you say, hey, all right, you've got this thing. Why has no one done this before, right? What is it that allows you to do this and get this whatever, you know, good thing that you're doing that no one else has done? And of course, this is something that's good in 101. It can help you identify inventive concepts, but it's also in general a good practice. It can identify, for example, points of novelty or arguments that you can use to sort of set yourself up for non-obviousness. Similarly, you talk to the inventor, you say, hey, what are the benefits? What does this thing do, right? They say, oh, this is great, you know, again, something that has some 101, you say, all right, well, when we implement this, you know, what happens? What are the benefits to this thing? And this can be good, again, in the 101 context, of course. It can show that you have improvements to computers or other technology, but it can also be good outside of the 101 area, right? Because this is something that you can show unexpected results, again, useful for obviousness. And I guess a practical example of this, so let's say that we have an invention and it's a way of incorporating data into forms. And we know that this is going to have 101 issues. How do we know that? Because we know about content extraction and transmission versus Wells Fargo, where they basically said, you've got this and that's abstract, and they invalidated the claims. So all right, we know there's 101 issues. What do we do under my advocated sort of less cynical approach to being strategic, trying to avoid 101 issues by using best practices rather than using drafting tricks? All right, well, what if the reason that no one has done this before is that previously you'd only extract data from databases which had published schemas, right? So that they had ways that they had described how their data is actually organized, and we found a way around that. Well, we can find this out by talking to the inventor and then use that as a way of describing the invention as not just a way of incorporating some particular data, but instead is a more general improvement of importing data from third-party applications, right? We're improving the computer as a tool rather than just using it as a tool. Similarly, what if whatever it is that we do to enable our data importing has some additional benefits, like, I don't know, decreased memory usage or higher processing speed, right? Something, we're doing this more efficiently. There's other people who've done data importing. What's ours better? Again, maybe we're talking about processing speed, maybe we're talking about memory. I mean, these are the kind of things that we can find out from discussing with our inventor, asking those questions like, well, what kind of benefits does this have? Why has no one done this before? And by getting that information and then using it strategically in our claims and in our application, we can put ourselves in a position to potentially avoid 101 altogether and put ourselves in a much better case if it comes up. And why am I so confident that I think this would work? Well, it's because that's essentially what the patentee actually did in Atrix software versus Greenshade software. Now, I wouldn't say I'd follow exactly what they did. For example, when they brought in those things that I just mentioned about processing speed and memory and the proprietary database schemas, they did that on a motion to amend a complaint in an infringement suit. On the other hand, they were dealing with a patent that had been filed and drafted pre-Alice. We're not in that situation, right? We're talking about patents that we may be drafting right now. And so we have the ability to take what they've done, or what they learned rather, and put that into the application itself so that we'll have that front and center to potentially avoid Section 101 rather than using that, again, as part of an amended complaint in an infringement suit. We can get out in front of it and hopefully avoid the 101 issues altogether rather than sort of use the more cynical approach that I described earlier, which again, I can see some cynicism because it's a hard thing. But I think by strategically applying best practices, we can probably avoid it and get good results anyway. All right, fine. So what if you can't? I mean, 101 exists. I talked in part 2 that even a cynical approach can't guarantee you're going to get away from it because all inventions have at their core some judicially excluded subject matter, right? An abstract idea, law of nature. All right, well, what puts you in the best position to deal with 101 if it doesn't come up, if our strategic application of best practices does not avoid the issue altogether? And if I was going to say one word, I would say that word is detail. In part 2, I talked about detail. I talked about cases where they included details in the claims and those beat back eligibility challenges. And now I want to go beyond that. And I want to say, however much detail you have in the claims, you should have even more in the specification. So for example, let's say I have a process, many steps, and one of the steps in it is that it has some kind of like real-time transcoding. I may not know to put that in the claims. There may be many, many steps. If I write literally everything in the process, I'll have a claim that's like 10 pages long. Okay, but guess what? Your spec's going to be 10 pages long, right? Your spec's going to be more than 10 pages long. You should have those details in there. And I can tell you from my personal experience that this can really, really help you. So I had one case, and I'm not going to sort of discuss all of the specifics of it, but I will tell you we had some 101 issues. They were difficult to get over. And we had an interview with the examiner, and I basically said, look, we all agree this is different from the prior art. And we have presented various arguments, and we'd gone back and forth. As I said, it was a difficult case. We'd gone back and forth. Here is why we think this is all very technical, and we provide improvements to technical process, etc. But what do you think? Like, what would make you feel comfortable with this case? And the examiner literally pointed to some a feature in the specification, something similar to, obviously not the same as like real-time transcoding, and said that if that were in the claims, that would address my concerns, because that's something, it's not, organizing human activity, right? Like human activity isn't real-time transcoding. It's not a mental process. You can't practically do transcoding mentally in real time. So you put that in the claims, you get it through. We did get it through, and we also were able to get through some related cases as well. That feature is not one that if I'd been saying, oh, I only want to, do the precise things in the claims, but because I had very high level of detail, I was able to have that there for the examiner himself to actually pick out And so we put into the claims, the client said this was fine, and again, we got a very nice result. The same is true, I also say really work the dependent claims. I talked a little bit about this in part 2 also, but an example, I use this in part 2 as well, is Berkheimer. In that case, you had broader independent claims that were invalidated, and the dependent claims, they said, look, these are claims that that you could be establish eligibility for. So I would say number one, the rule, if you want to put yourself in a really good spot to deal with 101 rejections, if the strategic application of best practices does not apply, or doesn't satisfy it, or doesn't help you to avoid it, is detail. And I'll actually say it's 3 words: detail, detail, and detail, right? It's like real estate. It's location, location, location. This is detail, detail, and detail. Now, I do recognize there are other approaches, right, that they do exist. I find that, I feel they're a little bit less reliable. So, for example, you can match your claims against the USPTO examples. Not a bad idea. It makes a whole lot of sense. I've had examiners, again, I do have interviews, I talk to examiners and say, what would help you? Some examiners have said, hey, make these look like the examples. You know, that's what makes me happy. Okay, fair enough. The reason I say this is, I think, a little bit less reliable is we know that after cases like Cleveland Clinic versus True Health Diagnostics, it's unclear how useful this is going to be. I think that the PTO examples, you know, they come, they go, they may go out of style. Detail never goes out of style, right? It's right in section 112, a detailed description of the invention. There you go. So I would say detail, again, I'm not saying it's a bad idea, but I'm saying that the detail is going to be a more reliable way of doing it. And it's something that I think you'll have better results with in the long run. And you can do both, right? Another one, right, you can try and match the patent office's, their framework, right, where you have ALA Step 2A, Step 2B, practical application, significantly more, that sort of framework. Again, it's very similar to the practical examples, though. I mean, that framework is something, you know, it's been in place since 2019. It replaced previous framework that had been in since like 2016. It's now 2021 as I'm recording this. There is a new administration, which means new patent office leadership. I don't know what is going to happen to the 2019 guidance. It wouldn't surprise me even a little bit if it is either replaced or changed very significantly. I don't know that, but I do know the history of the patent office, that new people coming in often means new guidance, new sorts of approaches to examination. And so again, I'm not saying it's bad to use the patent office's guidance. I think that would be overstating it, but I do think that it will be a little bit less reliable than the sort of really high focus on details that I described earlier as my preferred method. And again, you can use both, but I think focusing on the guidance to the neglect of details is going to be a lot worse than focusing on the details to neglect of guidance, because if you focus on the details, you'll always have support for the guidance. If you focus on the guidance, you will not have support for the details. So anyway, that is my, I guess that's the ultimate synthesis that I have, my ultimate recommendation that I wanted to make in this series is, look, I recognize Section 101 is hard, and ideally you don't have to deal with it at all. However, you can't guarantee you won't. And I think ultimately, instead of kind of a more cynical approach of really sort of exercising the draftsman's art and saying, look, ha, courts, you say 101 avoids the draftsman's art. Well, look at me. I'm using the draftsman's art to avoid 101. I think the stronger approach is to use best practices, use them strategically to try and avoid the issues rather than trying to just be, again, take a more cynical approach. I do also think that including a lot of detail in case those sort of strategic application of best practices, in case that doesn't help you avoid it, have the details so that you do have that as a fallback position. And again, you can use other approaches, but I think my recommendations on those are going to be a little bit more reliable in the long term. But we'll see. Again, as I said, there's a lot of changes. Supreme Court might, they might grant cert in American Axle versus NEPCO, which could turn everything on its head. We'll just have to see. But in the meantime, good luck, good patenting, and I wish you the best with your 101s. Thanks a lot.